Hello and thank you for joining me. This is the second of two consecutive videos which are about the child arrangements when there has been domestic abuse. Again, I'm just going to clarify, like I did at the start of the first video, that I am mainly talking about the domestic abuse which is occurring very, very commonly from a male to a female, and I'm talking about the domestic abuse that can continue through the co-parenting arrangement, which any kind of relationship, any relationship like the co-parenting relationship is open to abuse, just like any relationship could be. In the first section, we talked about the pathway that the child arrangements application would take if there's been domestic abuse. So we're going to, I'm hoping it's just going to flash up on the screen now, that you will see the flow chart, and it will show you, again, Form C100 with or without C1A. Now, if you recall, I said that mediation is not appropriate if there's been domestic abuse. As you're filling in Form C100, whether you are, well, you would be the applicant if you're filling in that form, and you can find where you can tick if there has been domestic abuse, and that would tell you that you have to fill in this form, this second form C1A, and it's also possible that mediation is not appropriate. Okay, so if you've got evidence of involvement from a domestic abuse agency, for example, that is something that the courts would accept, so that you got round this thing that they like you to do, which is to see if you can sort it out before you come in to the actual application process. It's not recommended for mediation because in an abusive relationship it is not a collaborative process. It's not two parents working together. It is one parent undermining and controlling the other parent. It's not appropriate. The applicant has made the application. They've indicated that there's domestic abuse because they've filled in Form C1A. So what if you are not the applicant? What if you are the respondent in this application and you've just received the application? So you might have just received Form C100 on its own. And if you recall, I said that you needed to complete a form which is an acknowledgement of proceedings. That's Form C7. Again, you can put that in Google. And again on Form C7, it's got the boxes that you must tick if you think that there is a risk of harm from domestic abuse, any form of domestic abuse. So with that will again tell you to fill in Form C1A, so both the applicant and the respondent have the opportunity to set out in this form just very brief details at this stage of what the abuse has been. And when you're looking at Form C1A, we're going to go into it in much more detail in a subsequent episode, so that you can see clearly how you should fill it in, what you should put in the different sections, page 3, a big complicated table, how you can set out the different abuse that's been happening there. At this stage, you just need to make the allegations. You do not need to be providing evidence at this stage. So that's the first thing that I want people to understand. It's helpful to know that you don't have to get all of it in for this first hearing. At the moment, I just want you to raise an allegation of domestic abuse and let the court know that that's what has happened in the past, or even may be happening as the application is being made. Form C100 has gone to the court. Form C7 shows that the respondent has acknowledged the proceedings. C1A has come in either from the applicant or from the respondent, and the court is then initially alerted to the idea that there is potential harm that could happen to the child. If you remember, the child's welfare is the court's paramount consideration, Section 1 of the Children Act. At the first hearing dispute resolution appointment, the same thing needs to happen before that, which is that CAFCASS need to speak to both the parties and they need to give initial advice to the court. One of the things I want to make clear in these videos is how to raise domestic abuse. You can see that first of all, you can raise it on Form C1A. If you have not been able to complete it on C1A, and even if you have, you should still repeat the information when you speak to CAFCASS. So you should point out that there has been domestic abuse, especially if this has been witnessed or heard by children of the application. You need to make sure that CAFCASS are also aware of this. It's good practice and helpful to set out a list of bullet points that you'd like to cover with the CAFCASS officer before the telephone call, so that you can go through those and make sure you've got them. If the CAFCASS officer has not received a copy of the application, or if they have not received Form C1A, you should check with them and ask if you can send a copy to them. CAFCASS will now become aware of an allegation of domestic abuse. This will appear in the safeguarding letter, in the what the applicant said, what the respondent said. It can sound a bit he said, she said here, and the CAFCASS officer will make these initial recommendations to the court. Quite often, if abuse has been alleged, good practice, and quite often it does happen, CAFCASS will say, no, we cannot say that contact is safe until we've determined these allegations of abuse. And we need to make sure that contact is safe, both for the children and for the parents that's alleging the abuse. So this is all happening before the first hearing dispute resolution appointment. One of the other things that I want to talk about is if you've not been able to speak to CAFCASS, make your allegations clear, if you've not filled in a C1A, how else can you tell the court that there's been domestic abuse? If you are approaching the hearing and if you are throwing up with the fear of having to face your abuser in the court, you may be wondering how you're going to speak at all. Another way to alert the court to the fact that there's been domestic abuse, and it may help as well if you're extremely anxious, is to prepare a position statement before the first hearing. This sets out what you want to say to the court and what you want the court to be aware of. Again, we're going to talk about how to write a position statement and what you should include in a position statement in a subsequent episode. It's another opportunity for you to set out what you need to say, and when you get into the court, as long as you've passed it to the court usher to pass on to the judge, you've given it to the applicant or respondent, the person on the other side, you've given a copy to CAFCASS, then when you're in court you can just say, my positions are set out in the position statement, and you can get your message across without having to say anything in front of your abuser. The first hearing dispute resolution appointment is happening. Now this is where things will change, and this is where things must change. So I'm hoping that you can see the flowchart on the screen. And the first thing that I want you to know is that because domestic abuse has been alleged, what must happen is that the court must consider whether the domestic abuse is being alleged and whether it's going to impact on the child arrangements. So straight away, you can see that as the red arrow represents the allegations of domestic abuse, this should engage Practice Direction 12J. And paragraph 5, which I'm going to read to you, says that the court must, at all stages of the proceedings, and specifically at the first hearing dispute resolution appointment, consider whether domestic abuse is raised as an issue, either by the parties or by CAFCASS, or otherwise. Remember, they're doing these checks. It may be that there's police information that's being raised that would concern CAFCASS and therefore concern the court as well. It kind of puts the other proceedings on hold. I'm showing on the flowchart that the allegation of domestic abuse has been made before the FHDRA here. So you can see that the normal proceedings are suspended and they will take a diversion. So the court, according to paragraph 5, and this is a new thing since the end of 2017, before that it only said that the courts may, at all stages of the proceedings, consider if domestic abuse is an issue. It now says the courts must. That's a big difference, and we were taken aside in law school, and it was in a lecture theatre actually, and it was explained to us that there's a lot to this interpretation of the black letter of the law. So the court may and the court must have very different meanings. So post late 2017, the court must consider if domestic abuse is an issue and if they need to make findings about the allegations. So you can see on the flowchart that it takes a circular route to go through, decide if it's going to make findings on these allegations. If it isn't, the court should give you reasons why that is. If it is, the court should give you directions so that these findings can be made. So the first thing that needs to happen is both the applicant and the respondent and the court and CAFCASS need to be clear about what those allegations are and what is being said about those allegations. So they will ask you to prepare something called a Scott schedule. If you are the person making the allegations, you will set out your allegations in numbered paragraphs, giving as much detail, well, as much specific information as you can, such as the date and exactly what happened, just in a one sentence. Again, you don't have to give a full statement or evidence at this point. You're completing a table called a Scott Schedule of Allegations, which we're going to go into in more detail later. That is then passed to the person who is subject of those allegations, i.e. the abusive personality, and the person subject to the allegations then gives a response in that table. So they might say it's denied, or it's accepted and it didn't happen like that, or it was an accident, or however they are going to respond. If they agree to everything, then the court may not need to have an actual fact-finding hearing. They may need to see what steps the person subject to the allegations has made to make sure that their behaviour is not harmful for the children. If the abusive personality at this stage is saying that they do acknowledge that they have been abusive, you should ask the court to record in the order that they have made acknowledgements about their behaviour and its impact on the children. Scott's schedule of allegations with the replies. If there's a lot that's being denied, then the court is going to have to hear evidence. It will ask the parties to provide further statements. This is where you will set out your evidence of each of your numbered points in the table, and you may have text messages, you may have photographs of injuries. You'd be surprised, we're going to go through this again in much more detail, but you'd be surprised at how much evidence people don't realise that they have. The first evidence that you've got is your evidence in chief. That is what you will say to the court. So you will say what happened, and that is evidence, one form of evidence that the court will have to look at. If a fact-finding hearing has been ordered, there may be lots of other directions that the court would like so that it can properly determine the truth of the allegations. These are typically things like hair strand drug testing, so that they can test for alcohol or drug abuse. They may include medical records from either or both parties. They may include police records, and the parties, an order will be made so that information from the police is passed into the court, and so that it can be considered by CAFCASS, it can be considered by the court, so that they can, again, it's coming to the truth of things. At this stage, in a fact-finding hearing, from what I've seen of it in family law, when it is working, this is where I feel really confident about the law. I feel that if evidence was considered to the detail I've seen it considered at fact-finding hearing, and these hearings can go on for 3 days, then I think people can't fake it, people can't make it up. Could I be teaching somebody how to make false allegations of abuse? Or could I be teaching an abusive personality to be able to evade detection? I don't believe so, because I believe that this evidence-checking process of the court here means that it can't be cheated. It can't be, the wool can't be pulled over anybody's eyes here. That's what my impression is. That's what I hope. And this is good practice. So this is when it is working, the court system and the court way of dealing with abuse. The court, as a result of a finding of fact hearing, will make findings in respect of the numbered allegations set out in the Scott schedule. Those findings are then incredibly significant. those findings will determine the truth as far as the court is concerned going forward. This information will be fed back into the proceedings. The normal proceedings are going to restart here with the findings that the court has made. So what the court has decided is the truth of the allegations of domestic abuse. Something else that I want to show you, while the court is making a determination about these allegations of abuse, looking again at the flowchart, if you recall in the first episode I showed you that there's an assumption at 2A of the Children Act which says that the court may presume that the involvement of both parents in a child's life is in that child's interests. Now, paragraph 25 of Practice Direction 12J says that here, at the first hearing dispute resolution, if this is where contact has been alleged, the court should not presume that the involvement of both parents in a child's life is going to be of benefit. The court may ignore that, and what they may do, or what they have to do, is so I'll just read this out. So this is Practice Direction 12J, paragraph 25, where the court gives directions for a fact-finding hearing, or where disputed allegations of domestic abuse are otherwise undetermined, the court should not make an interim child arrangements order unless it is satisfied that it is in the best interests of the child to do so, and that the order would not expose the child or the parent to further harm. This is backed up by paragraph 26 of Practice Direction 12J, which says that in deciding whether there should be interim contact, the court should apply this welfare checklist that I've referred to before, section 1.3 of the Children Act. They should check the wishes and feelings of the child, any risk of harm. They also, according to paragraph 27, must consider what they can do to make any interim contact safe. So they may ask if it can be supervised. They may consider if there are perhaps child contact centres that can be used, and they may also decide if indirect contact would be more appropriate. So indirect contact is going to be letters and cards, telephone calls, and of course in this day and age potentially video calls as well. Again, something coming up for a later episode. We'll talk about how to deal with indirect contact, how to deal with contact that's happening at a child contact centre, and we will talk about the different types and the different orders or safeguarding measures that the court could take at this stage. Findings have been made. Let's assume that findings have been made where the abusive person, or the person alleged to be abusive, has been found to be abusive. A lot now depends on how that person responds to those findings. I nearly said allegations, it's findings now. If a person is being abusive, remember Pat Craven's Dominator, remember that they are a liar, remember that they will say it never happened, the evidence was made up, the evidence was contrived, the children were coached, I never did that. And if they keep disputing the findings, then this means that then they can be seen not to accept them, and it may be, as we all come into the dispute resolution appointment with the abusive personality where findings have been made, not accepting what's happening, and a final order might be made, because a person who is not accepting the findings, part of the abuse, not being able to acknowledge what's happened and the impact of your behaviour, or of the behaviour on the children, on the parents of the children, on the mother of the child, and how that has a knock-on effect for the child as well. The dispute resolution appointment would happen with the findings having been made. The court will want to assess how the parties are responding to those findings. The Section 7 report may be ordered at this point, so The CAFCASS officer or Children's Services, whoever's doing the Section 7 report, will then interview both parties, speak with the children, try to understand as well how much acknowledgement there is of the harm that has been caused by domestic abuse. With that, the court will be able to decide if they can safely order contact, or is it that they have to look at some kind of domestic violence perpetrator programme, so that the person who is abusive can learn about and modify their behaviour. If they go on this course and change their behaviour, great. To be able to get on these courses, they're very, very difficult to get on, because the person who is abusive has to approach it with the correct attitude, the correct presentation about how they feel about their own domestic abuse. And this is something that it can't be faked. If a person is abusive and they're pretending not to be, it's courses, the domestic violence perpetrator courses, they've seen it all. They've seen people acting nice, acting charming, because of course the abusive personality can do that. Acting charming, and they know that it's not a genuine open conversation about, my goodness, I don't like my behaviour, what can I do about it, how can I change it? The judge or the magistrates will make a decision about how much contact is safe. If contact is safe, is it still disputed how much time the child should be spending with each parent? What kind of contact could happen in the meantime while the abusive parent is receiving help for his behaviour? And I am being gender specific. Then they might decide that interim contact should happen until they've completed the course or made significant progress on the course. The idea is here that there is a mechanism for the abusive parent to genuinely acknowledge and accept their behaviour and move forward to change it, so that they can re-establish a relationship with the children and a co-parenting relationship which is healthy. If they cannot do it, then of course findings have been made already. If they do the programme and then revert back to their abusive self, it all adds up, doesn't it? So that person, you can then see that it's an even bigger act, and you can show the court, well, last time, this is exactly what was said last time. So I'm hoping that I've given an overview in the first episode of the steps that would be taken in a child arrangements application where there is no abuse, potentially some conflict, high conflict parenting pathways may be going on there. And this is very different to a situation when there is domestic abuse being perpetrated by one parent against the other. It has incredibly damaging long-term effects on both the other parents and on any children that are involved. That in itself is the subject of another video. My aim in these two videos is just to give you an overview as best I can of the two systems. I'm just going to finish quickly with one more thing about family proceedings that people may not know. It may be that the police have been involved in a relationship, and it may be that they've already pursued something on a criminal level, maybe an assault, a sexual assault, anything like that. And a person quite often asked about how the family court would treat it if they've been found not guilty. So I need to talk about, just quickly, about the different burdens of proof, the different standards of proof. In the criminal court, this is beyond reasonable doubt. In the family court, when the court is going through the fact-finding hearing and finding the truth of the allegations that are set out in the numbered table, it will then just use the balance of probabilities. Is it more likely than not that that incident happened, that they may only have the evidence in chief of both the parties? This parent, they said, this parent, they said, and it may actually come down to just a feeling of who is telling the truth. It's a very fine balancing act. And once the court have the information about any harm that's being caused, they can then do a second balancing test, which is to work out whether it's better or more harmful for the child to see that parent than it would be for the child not to have a relationship with the parent. And that again is a balance of harm test. that's the last thing really that you need to know about the child arrangements when there's been domestic abuse. As I said, there's several aspects of this that I can go into a lot more detail. This is just to give you an overview of the two processes, and I intend to keep referring back and going into more detail at the different stages. I hope that that's been useful and informative, and thank you once again for your ongoing support and for watching the Survivor Diaries. Thank you very much, and goodbye.